Going. I just wanted to welcome everybody. The meeting is being recorded, as I mentioned earlier. So welcome to DEF's Cornerstone series. Cornerstones is a DEF program focused on developing hard skills for venture capital and entrepreneurs. For example, past events have been financial modeling, pricing, digital marketing, had the angel investing for both sides, for the angels and for entrepreneurs. And today we have IP strategy, which is critical for many venture capital investors and entrepreneurs. So this Cornerstone series is for you. So if you have a topic, something substantive skill that you would like to hear more about or area, let me know, because that's what it's here for. And we could very likely get an expert in the field for you. That's the whole idea, is to get you get high-level experts for our members and guests. Or if you want to speak, let's say you have an area of expertise that you want to share. This is also to get some visibility for all of you, for our entrepreneurs. We're soon going to launch a practice pitch night for members that are going to go on roadshows to raise money. And we'll have seasoned angels or venture capital people at VCs to critique you, in a friendly environment and review your deck and give you an opportunity to practice. So that's something that's coming. And also, we're going to have a crypto series, blockchain series as well, from others that are very interested in setting that up. So today the topic is IP. It's actually, today are my colleagues. I'm a corporate lawyer at a boutique law firm, May and Mark in DC. I help out with, that's how I got into this area. I help VC emerging companies raise money, do M&A, and other things. And my colleagues, Andrew and Larry, are very seasoned IP lawyers, which is very helpful for me. And so Larry Sandell, he is an IP attorney, and he has a lot of all-around experience in strategy, procuring patents, litigating, and even appellate work. And also he has personal experience with startups. He started a medical device company, so he's been inside and outside all over with IP and startups. Andrew is also at May and Mark, and he's an IP litigator. He's a trial attorney that helps companies resolve their intellectual property disputes in state court, federal court, and the International Trade Commission. He heads May and Mark litigation team, and he's also an Army veteran. And he also teaches at law school, American Law School in the DC area. And I'm also, I was former Navy intel, so we won't hold the Army against Andrew. And I'm going to hand it over now to Larry to start. And we'll have Q&A at the end. If you have questions, feel free to put it in the Q&A box, and we'll get them answered.
All right, thanks very much, Jed. I guess just to start us off, yeah, we're here as attorneys from May and Mark, and we've dealt with all sorts of IP issues across the board. But I'm also here as well as part of GRIP, which stands for Growth in IP, which is it is May and Mark's platform for emerging companies in venture capital, where we have plenty of expertise in IP, as you know, as well as in corporate law. And then we have a lot of non-legal professionals who have expertise in marketing, finance, data analytics, you name it. So we try to sort of endeavor to be a one-stop shop for emerging companies there. But today, of course, we are going to be focusing on IP issues. We'll touch on everything, but we will mostly hone in a little bit more on patents. And while we'll certainly be getting into legal details all around, we recognize people are here for the business implications. So to the extent that's possible, that's exactly what we're going to be focusing on. So just as a quick outline, I don't know if Andrew, you want to run through that, and then I'll get started.
Yeah, happy to jump in. Welcome everyone. Thanks for having us. we hope you have sort of two big takeaways from today. And the first is just an overall understanding of the types of IP you should consider protecting as you grow your company, as you grow your ideas. And we also hope that you gain an understanding of how you can use IP or intellectual property both offensively and then how you can respond defensively to protect yourself from other companies' IP. So you can see here on the outline, we're going to talk about sort of the basics, IP 101. We're going to talk about the sort of two sides of IP, how you can avoid potentially infringing, and as well as what you can do with IP to protect yourself and protect your ideas in your company. And then Larry's going to talk a little bit about growing, your strategy for protecting IP. And we're also going to talk, that's a little bit more my ballywick here, we're going to talk about enforcement and the defensive side of things should it come to that, and also talk about some ways to mitigate your risks down the road.
All right, thanks, Andrew. So to start off with the IP 101, these are the basic types of IP protection. Utility patents, when you hear utility patents, usually when people mention patents, that's what they're referring to. And that really protects technology. It protects what people consider inventions. So machines, software, algorithms, formulas, processes, very, very wide range of things that can be protected. Business methods too, potentially, although that is that's a very tricky one and probably a discussion for another day. Also, there are design patents, which is another form of patents. And while utility patents protect utilitarian or functional aspects of inventions, design patents really just protect the way something looks. Trade secrets are another method of protection, which really just involves keeping whatever your know-how secret and giving it effective protections that prevent somebody from stealing it, or if somebody does steal it, you have some recourse. Trademarks are effectively branding. It protects words and symbols that use to designate the origin of the product, your company. So that may include your house marks, particular products you have, or branding slogans. And copyrights protect essentially artistic expression. So the classic ones, of course, are movies, art, music, and so on. And so taking a look at sort of those same types of IP protections from the perspective of what you're protecting, when you're looking to protect technology, your inventions, utility patents and trade secrets are really, I guess, number 1 and 2 of the ways to do it. With utility patents, you will ultimately have to disclose your secret sauce to the world, and in exchange, you get exclusive rights and that you can protect. Trade secrets, you keep everything secret, but if somebody else is able to reverse engineer your product, or if they're able to stumble upon the same idea, you really have no protections. Design patents are also helpful, especially in app development. They can protect your user experience. I'll have some examples there. And then if you have if you're doing software as well, you can protect the expression of your software using copyrights. And it's an interesting form of protection, because if somebody uses a similar algorithm that you use, but they don't actually copy the way you express yourself in code, it doesn't offer you much expression there. But what it does do is give strong protection if somebody is wholesale copying your coding. Turning to artistic expression, the classic IP protection for that is copyrights. But design patents also play a big role here as well. If you are selling a product and you've made it look really cool, or even the packaging look really cool, you can protect that expression also with design patents. And coming down to branding, trademarks are sort of the number 1 IP protection. You can also copyright your logos for either additional protection or sort of protection on the cheap. But trademarks are really where you want to go with that. And then when it comes to business ideas, you really have to focus on non-disclosure agreements. keeping them close to the chest and trusting the people you talk to. It is extremely hard to get any true IP protections beyond that. So I'm going to start off here focusing on patents. And if you're familiar with patents, bear with me for the next couple slides, but it's always good to start at the beginning. So a patent really consists of three main parts. It's the specification, which is a description of the invention, how to use it, how to make it, and so on. Figures, which are pictures of the invention, and they help support the specification, and the claims. And the claims are the operative part of the invention, the operative part of the patent. And you could sort of think of these as the property lines. If anybody's product falls within the scope of your claims and practices all the claim elements, they would be infringing your patent. So it's sort of what you own, it's what you have exclusive rights to. So on one level, you want those claims to be as broad as possible, so your exclusive rights extend very far out. And that really, those claims, however, can be harder to get, even though they are more valuable. And if you end up suing somebody, it may be harder to protect those claims in a lawsuit and maintain their validity and keep them alive. The narrower claims would be a smaller area, a smaller scope that you'd own, are easier to get, but your competitors might be able to design around your claims. They might be able to change their product in some minor way where they're no longer infringing your patent, but they're still accomplishing the same thing that your product accomplishes. And therefore your patent might be a nuisance for them, but it's not going to truly block them out of the market. And you are in a sort of a standard patent, has up to 20 claims included in your filing fee with US Patent Office. And my strategy, and I think is probably among the best strategies, is you want to get the broad claims and you want to get the narrow claims in those 20. So now I'm showing some examples of what the anatomy looks like, not including any specifications. Those can be pretty long and detailed and not too interesting to read in a presentation. But I have a figure from a patent that I prepared and was issued. It has to do for a light box that's used for cultivating plants. And so on the left is the figure. On the right is claim 1, which is an independent claim. And you see it has a number of elements that really describe what are the property lines. So if anybody else makes a light wall that hits each and every one of these elements, that light wall would be infringing this patent. Claim 2 is what we call a dependent claim, and it's dependent because it depends on claim 1. And so to infringe claim 2, it has to practice all of those elements of that first claim, as well as the additional one that talks about the first set of mechanical devices comprising a set of wheels disposed on the bottom side. So in short, it has to do everything in claim 1, and it has to have wheels at the bottom. And so 2 would be a little bit narrower, and 1 would be the broader claim. And this is just as an illustration, but this is sort of a typical claim format, but they apply to basically all industries. So utility patents give you exclusive rights for up to 20 years from the filing date of the patent. And the important thing for entrepreneurs to know, starting from day one, is that the filing deadlines for utility patents are very unforgiving. You have to have your patent application filed before anyone else files a patent on it, or anyone else publicly discloses or publicly sells the invention. So if somebody beats you to the patent office or beats you to the market before you get to the patent office, you're out of luck. You're no longer going to be able to file a patent. The other major rule is that a patent application must be filed no later than a year after you personally or your company publicly uses your invention or publicly discloses your invention or sells your invention. It's certainly best practice to file before you do any of those things, but you have a 12-month window to get around that. So once you file a patent with the patent office, there's a process called patent prosecution, which is how you get the patent. And it really consists of a negotiation between the patent attorney and the patent examiner who works for the US Patent and Trademark Office, and which is the USPTO for short, as you'll see this in a few places. And so the USPTO and the examiner's job is to make sure that the claims that you eventually might get, that they're written in a proper way, that they're novel, that no one else has invented this before, and that they're not obvious. And really what the examiner does is he searches for what's called prior art, which may be older patents, it may be academic publications, it may be products that the examiner finds by Googling your invention. And he looks for prior art that predate your invention. And it looks at those items, and then the examiner will say, well, is this set of claims, is this invention obvious in light of what I found? And that's really the back and forth. So if an examiner says, hey, I think this is obvious, the patent attorney can come back and say, I think you're wrong for reasons X, Y, and Z. Or the patent attorney can say, okay, let's just assume you're right. I'm going to narrow the claim scope. I'm going to add additional limitations. And with these additional limitations, we don't think that the claims are obvious anymore. So this process typically takes between 1 and 3 years. Your application by default, your patent application by default will publish after 18 months after it's filed. And so you don't have the patent yet in most cases, but it will be disclosed to the public and people will know your secret sauce. If you are seeking to file internationally, you really have no choice. You have to allow it to publish after 18 months. But if you're not filing internationally, you can tell the patent office that you don't want the patent application to publish until the patent issues. And in that way, you can sort of operate in a stealth mode. And that way, if you ultimately don't get a patent, or you decide at the end of the day, maybe we should just keep this as a trade secret and not get a patent, then you have that opportunity and your patent will sort of just disappear and it'll never become public application. Turning to design patents here, design patents are a bit different. They focus on, of course, the ornamental design. You have exclusive rights to your design for 14 years after issuance, after the design patent issues, and it only protects the ornamental aspects of your design. It doesn't protect any functional features. And you're sort of able to, when you file a design patent, to pick and choose which features you really want to claim and own, and which are just contextual, that sort of just illustrate how that sort of design is applied. So, for example, the picture that I have directly below, you see an electrical outlet, and this is a design patent that I had prepared. You see dotted lines around most parts of the electrical outlet, all around the back of it, the sides, and so forth, and even the company logo on it. But you have solid lines that illustrate the positioning of the outlets, as well as some USB ports, and as well as some LEDs. So those solid lines claim sort of essentially the relative positions of the USB ports and the main outlets. And this is a design patent that's issued. So someone else could certainly make a electrical outlet with 3 USB ports and two proper regular outlets there, and not infringe this patent. But if they're arranged in a manner that's substantially similar to this, they're going to infringe the patent and they won't be allowed to do it. As I also mentioned before, the design patents are good for applications, graphic user interfaces. On the right is a design patent that Apple had filed that has to do with turning pages, effectively turning pages on probably an iPhone, or maybe it was on an iPad, would claim it on both, and essentially is a flip book. So it's not just a solitary image of a product, but they're claiming the design of this user experience where you can move your finger across the screen and essentially a page flips. And you can see it from figures 1 to 3 that the page is flipping. So I'm just going to touch on a trademark very briefly. This is your branding. Trademarks can last forever so long as you continue to use them in commerce. And they really protect you by allowing you to exclude other people who use your trademark, either a logo or a word mark, or so they prevent people from using those marks or marks that would be confused with your mark. You can get federal trademark registration, which is really the gold standard and makes it a lot easier to litigate and prevent other people and stop other people who are using similar marks. And then there's also what's called common law trademarks, which are effectively, you're using a trademark, you're using a brand in commerce, you have rights to the brand just by using it in commerce. The problem is it's a lot harder to prove that you have a trademark. So if you have to sue somebody, it becomes a lot more of a headache. It's much more of an uphill battle. And when you see that R symbol with a circle on it, back up to the federal trademarks, that means it's a federally registered trademark, and it really gets people to stay away. When you see the TM, it really just means that you think you have a trademark. Most people don't actually know the difference, so you really can just use the TM even if it's not registered, and you'll scare probably 90% of the people away, and it's probably worth using, but it doesn't have a really much additional legal force. There are also certain states that allow you to register trademarks for use just within the state, but those can be those aren't quite as strong, especially in this age of the internet. Touch very briefly on copyright. The life is extremely long. For a work by an author, it's 70 years after the author dies, or 95 years after publication for a work that somebody made for hire. So you have a long time. And it really only protects from copying, but not if somebody comes up with it on their own. It's always a very good idea to copyright or register copyrights for your websites. It can be good for a source code, as I mentioned before. And they're very easy to register with the US Copyright Office. You pretty much just pay a fee and pass the documents over and fill out a few forms, but they're not examined in the way that patents are, in the way that trademarks are. And I'll also touch here finally on trade secrets, which is any business or technical information that has value, that isn't known to the public, and that you've taken reasonable efforts to preserve secrecy. And that really means having all of your employees sign documents saying they understand the secrecy of certain documents or information, having third-party vendors who are accessing it sign NDAs, password protecting your websites and databases, etc. So this really just offers protections if somebody actually steals your data or information or improperly gets it, whether it's via a disgruntled ex-employee or a hack. It gives you protections there, but it's no protection against somebody coming up with that same information on their own. So that's sort of an overview of all the main parts of IP. There are also planned patents and a whole ton of other ones, but these are the ones that are relevant to probably 99% of emerging companies in VC. But I want to touch on this point, emphasize this point here about the two sides of the patent coin, and it's really two sides of the IP coin, because it's confusing to a lot of people who haven't worked in this space. A patent is fundamentally the right to exclude somebody from doing something. And really any unpatented technology is going to default to being in the public domain. So because of that, there's really two sides of the coin. There's one side, which is your patents, and then the other side is everybody else's patents. Now, your sides allow you to exclude others from practicing your inventions. And, by the same token, your trademarks allow you to exclude others from using your mark or similar marks. With your patent, so you can give permission for other people to use to practice your claims and use your invention. That's frequently called a license. And if somebody uses your invention and doesn't obtain your permission, you can sue them and collect damages for their infringement of it. And Andrew's going to get quite a bit into that later. Some key points, though, is that your patents don't actually allow you to practice your invention. You might be allowed to use it by virtue of the fact that components of your invention, all the components of your invention are already in the public domain, but somebody might have a patent on technologies that are necessary to practice your invention. And if you're not buying those technologies from that person who owns the patent, you might have to get a license before you can actually practice the very thing that you invented. The other thing that a lot of people don't know is that you don't actually have to use your invention to get a patent. You don't even have to physically make it. You just have to be able to describe it in a way that's sufficient for a sort of the average person, the average engineer in your field to make it. The tails of the coin is other people's patents. And that is where you need to watch out that you don't infringe other people's patents. If you do, you can be stuck with substantial liability from patent lawsuits. And as I mentioned before, so other people's patents can actually prevent you from using your very own invention without getting a license. So I'm going to turn now to just talk a little bit more about the process and some of the main strategies of getting a patent. And I'm running a little behind here, so I'll try and push through this a little faster. One great way for startups and emerging companies to preserve their patent rights is by filing what's called provisional patent applications. And these essentially save your place in line. You can get them on file before, you should get them on file before you're making any disclosure to anybody, either if you're, even if you're talking to potential funding sources, even if they have an NDA, it's really best practice to get them on file. And you certainly want to get them on file before you begin to sell your product or publicly disclose it. And in this provisional application, you want to talk about a lot of different ways that your invention can be made or different versions of it, which in the parlance of patents, it's called embodiments. So you want to outline all these ways. So not only the way that you think is the best and you plan on making your invention, but also ways that your competitors might design around it, because you don't want to prevent them from just making exactly what you're making. You want to also prevent them from making things that are very close to it. Now, a provisional application is fairly informal, but it expires after 12 months. So basically, you have 12 months after filing a provisional to file a non-provisional, a standard patent application. And when you do that, you can claim priority all the way back to the provisional. So this goes back to saving your place in line. And what's really important here is that the provisional is completely confidential until you file a patent application that claims priority to that provisional, and that patent application is either published or the patent eventually issues and that patent is published. So it's sort of a way that you can have your cake and eat it too. You can set the stage for protecting giving yourself patent protection by filing a disclosure with a patent office, but it stays secret. So later on, you can decide if you want to keep it as a trade secret, or if you want to have that date and file your patent, and then you have an earlier date. And the earlier date's important because that date is when the prior art must be dated before, in order for the examination and so on and so forth. And while provisional application can be fairly informal, the important thing to think about in writing it out is whether or not the average engineer in your field or your industry could make the invention after reading it. An example is you can't just say, I invent a computer and it's twice as fast as any computer ever built. You have to say how you did that, or at least say how exactly somebody could do that. The patent office really is in the business of giving patents for wishes, for inventions you wish you had. So it's not really the idea of what you want this product to do. You have to say how it actually does it or how it could do it. Another thing that's worth keeping in mind is a PCT application, and PCT stands for Patent Cooperation Treaty. And this is also known as an international patent application. And it sort of works as a provisional application, but it preserves your rights basically in anywhere in the world, except for Taiwan, that you might want to file. And so it gives you basically 30 to 32 months to file a patent application in the countries that you might want to go to. And this is important because while it's somewhat expensive to file patent applications in the United States, if you're filing in 5 countries, 10 countries, the cost starts going up dramatically. So a PCT applications really enable you to get moving with your business, seeing where, seeing what kind of traction you get in the US or wherever else, seeing what markets you might be interested into. And so later on, as that 30 or 32 month deadline approaches, you'll have a much better idea of whether or not the expenditure is worth it if you want to file in Europe or in Canada or anywhere else. So looking more to the kind of patent strategy as a whole, and not just getting the patents, they create value for companies. The first and foremost, they can provide a competitive advantage. They give you exclusive rights. You can push your competitors around, hopefully, and tell them that, well, they cannot practice this certain invention. And even if without saying it, you may scare them away just by having the patent. And of course, I have the word cudgel there because some people use patents quite aggressively and make lots of threats against their competitors. The patents can also be an indirect defense to a competitor's patents. If you're in the same field or a similar field, they might have patents that you infringe. And in that way, you can say, okay, if you give me a license, we'll give you a license. It's known as a cross license. These are very common, in, especially, for example, in the microchip business, where a lot of the major players have thousands of patents, and they all infringe each other's patents, so they have to make a deal or business would grind to a halt there. Patents provide a comparative value by essentially illustrating your IP value to investors and potential acquirers. And there are, of course, also potential revenue streams from licensing, from selling your IP if you don't need it later, and potentially from litigation. When drafting this claim set, the most important things that I look to, which I think everyone really should be looking to in preparing a claim set and seeing how valuable it is first of all, does it actually box out the competition? Is it easy to design around? Can you really block them or scare them enough that they'll stay out of the space? You want to have those broad claims to avoid design arounds, and you want narrow claims because those can hold up a lot stronger when it comes to litigation. And the last thing to look for is observable infringement. And this can become very important when you talk about manufacturing processes or software algorithms. It can be difficult to tell if a patent is infringed if the way that it works is always behind closed doors. So if you don't have a patent, or if you don't have claims that cover an actual product, but only a particular way of making it, you can really only guess until you get into litigation that one of your competitors might be infringing your manufacturing process claims, or same thing with software. So you want to sort of see, you want to be able to see how if the user-facing parts of the software algorithm infringe or not just some part that's hidden on a database. And I will got one more slide here, and then I'll let Andrew go. I'm running out of time here. In building a portfolio, there are a couple of main techniques that are used. One is called a continuation application. And basically what this allows you to do is after you file a first non-provisional application, you can continue to string along patents that claim rights to that first one, and as well as claiming rights all the way back to any provisional applications. And basically with these continuation applications, you file a patent application that looks the same, but you have new claims. So effectively you are claiming different aspects of the same larger invention. And what some companies do is they look at what their competitors might be doing, and they really try and draft those claims to go right on top of their competitor's product. And that can be a very, very valuable tool. There's also what's called continuation in part applications, and those allow you to add something to the description as well as adding new claims. And then there's sort of a technique that I like to do in moving forward with using both continuation applications and continuation in parts is that thing is called omnibus patent applications, and that is where you really throw almost everything into your original patent application, and then you claim only kind of that first set of claims that you think might be the most valuable aspects, but your patent application will support future applications on all the other aspects, but you don't have to shell out those additional resources up front. You can delay those costs to the future, see how your business goes, see which aspects might end up being more or less valuable. And the only sort of bonus tidbit here is that if you file a utility patent application, a non-provisional one, you can also include the pictures of your ornamental designs, and you can then later claim priority for future design patent applications. Now I'll hand it over to Andrew to talk about how you actually may or may not use these patents.
Thanks, Larry. So I want to go back to his analogy with the coin for a moment. On the head side, the offensive side, if you make the business decision to sue a competitor for infringing your patents, you're going to file that case in district court. Most intellectual property litigation takes place in federal district court. And I'm going to use patents as the example here rather than talk through each type of intellectual property and how those disputes would work out in court. Patents is probably the most complicated of the IP when you get into court. And I think it sets the stage for what you would probably expect for a trademark case or a copyright case. So I mentioned business decision to sue a competitor, and I really think that's important. That's something that we advise as litigators at May and Mark. It's really a business decision because there's a cost here. There's a potential market impact on your business, on your customers, and certainly your relationship to the market and your competition. And one of the reasons why it costs what it costs is because of all these procedural steps you can see listed here on this slide. A lot of other civil cases don't have these same procedural steps. A typical breach of contract case is not going to have claim construction and some of the other things that are sort of listed here on this slide. And I'm going to go through some of those here. But what I want to emphasize is that the cost for patent litigation is higher than a lot of other litigations, in part because of all these procedural steps. And you also probably need to get, good experienced counsel to help you with that, which unfortunately can raise the cost somewhat. So I want to highlight a couple of procedural steps here. This doesn't highlight every step, but I want to look at the first one there, which is claim construction. Larry spent quite a bit of time talking about claims and broader claims, narrower claims. Ultimately, if we go back to the analogy of this is a property, kind of like your house, you own this particular part of the land, the court has to interpret what those words mean in the claim. And so that's a very important procedural step. And the judge will actually decide what those words mean. And each side will get an opportunity to present their arguments as to how to interpret. For example, in Larry's lightbox example, there were certain phrases that were used. And what did those exactly mean? We have to put some words around that. And that's what we do here with claim construction. And that's an inflection point in any of these patent cases where if you get a very favorable claim construction, you might force the other side to settlement at that point, or you might force them to concede infringement and immediately appeal those constructions of the terms to the next higher court. So there's other inflection points as well in a litigation like this. After claim construction, you might have you will have expert discovery, and that's another point in the process where you could have a good opportunity to settle if you have these experts that you hire. They're typically independent third parties. Often they're academics or practicing engineers who will work for one for each side typically, and it's their job to work with the attorneys and then offer their sort of independent opinion about the issues. So they're going to look at somebody's, for example, the light box that Larry had. They're going to look at the competitor's light box and say, I've looked at the claims. I understand how the court wants me to interpret those claims, and I've looked at the competitor's light box, and it's my conclusion that they meet the claims for these reasons, and they would write a very lengthy report. And all of that, again, unfortunately, raises the costs. These experts are not very cheap. But expert discovery can be a point in time where you might also have another opportunity for settlement or sort of a business arrangement of some kind. It could be a license, it could be some other sort of agreement. And then I want to talk about a couple other things here with a patent litigation. You can ask for, if you're the complainant, if you're filing offensively, for a jury or a judge to decide your case. A jury is typically the default, and the jury will also decide if the defendant, when they appear in the case, requests a jury. And that's part of the challenge. The challenge that Larry and I have as trial attorneys is to take the technology that's described in these patent claims, work with our clients to then be able to describe the invention to a jury, a jury that may or may not have a good high school education, may or may not have a lot of science understanding. We have to explain that technology to them. And it can be quite complicated. And it can also be complicated to try to explain that to a judge. These judges see all kinds of cases, particularly in district court. They have a criminal docket. They also have a civil docket. They don't see necessarily patent cases every week. So we do have to spend some time explaining the technology to them, and that's part of the challenge. And so we like to work with our clients to try to do that, to tell their story, but also to tell their story as it's explained in their patents that they own. Now, after a jury makes its decision in one of these cases, the losing side can appeal to an appeals court, which is the next higher court. And then if you get an adverse decision there, you can potentially even appeal all the way up to the Supreme Court. There's not usually that many Supreme Court cases in the patent world, but when there are, Larry and I are watching them with bated breath. But there have been, on average, a couple every year in the past 5 or 6 years or so. So if we could flip to the next slide, Larry. I want to talk a little bit about the other side of the coin, defending yourself. If you're worried about a competitor who has a patent, you have a couple of options, and one of them, you could potentially file another case, a court case in federal district court, sort of preemptively saying, well, I want to challenge this patent. It shouldn't have been allowed by the patent office. There's other inventions that existed or printed publications that existed before this invention that either made the invention already, or if you make some minor modifications to it, would have made that invention obvious to someone who who works in this area. One of the things you have to have, though, is that you need to have some kind of threat of a suit hanging over your head before you can file one of these declaratory judgment actions. And the roles reverse. If you file one of these, you're now what we would call the accused infringer, and the defendant would be the patent owner. And there's a number of reasons why you might do this. You might want to preserve the friendly district court that's friendly to your business. It might be in your backyard. You might get a jury that knows that you're in this neighborhood and that they're going to hopefully be more friendly to you for that reason if you file first. Whereas if the plaintiff or the patent owner files somewhere else, it may not be as friendly for you. So that's one sort of strategy you can use to sort of on the defensive side, get out ahead of the other side if you feel like you've been threatened with a lawsuit. If we could go to the next slide, Larry. I want to talk a little bit about one other option for litigation in the patent space, and really in any IP space. This is an International Trade Commission investigation. A small number of cases are filed there every year, roughly in the 50 to 60 range, which is really a small percentage. But the idea here is that it's a trade forum, and ultimately their orders at the end of an investigation, if they find there's been a violation based on patent infringement or trademark infringement, they can order customs to block the importation of the accused infringing device. So the ITC, the International Trade Commission, gets a lot of press because some of the biggest players in the markets come to the ITC because they want to try to stifle their competition. So there were numerous cases where it was Apple versus Samsung or Samsung versus Apple, with the threat of being told that you could no longer import an iPhone or an iPad because you infringed Samsung's patents, or vice versa if you were Apple asserting your patents. So the ITC can have a very powerful remedy. You don't get damages, you don't get money at the end of a case, but you're going to bring Samsung or Apple to the table very quickly in any sort of licensing negotiations or some sort of settlement negotiations if the ITC has ruled in your favor and is asking customs to block the importation of your products. The ITC, unlike a district court, has nationwide jurisdiction, and it can also address acts that occur overseas. And that's really what happens here is if a knockoff is being made in China and then it's being imported into the United States, the infringing act may actually have occurred outside the United States, but the good is being brought into the United States and the good was made with an unfair method of competition, the patent infringement or the trade secret theft. And so that's what the ITC is trying to address. And unfortunately, there are no juries at the ITC. You typically first have a hearing in front of an administrative law judge, and then that decision is reviewed by the commissioners. There's 6 commissioners who are appointed by the president, and the statute requires that there be 3 Republicans and 3 Democrats, so it's always evenly balanced. And ultimately, they make a decision on the issues. And then if you get an adverse decision there, just like in district court, you can appeal to an appellate court, which is the Federal Circuit in DC. And then potentially from there, you could appeal to the Supreme Court as well. So I want to just quickly go through some side-by-side comparisons on the next slide, Larry, thanks. So the remedies in the ITC versus in district court, where DC up there is district court and ITC is the International Trade Commission. So in district court, you can get damages for lost sales. You could get a reasonable royalty award. Those are, real money could be handed over at the end of a case. And you also have the potential for an injunction, which would be something like stopping the competition from selling their product. In the ITC, it's sort of the opposite. You do not get any damages, but the remedy at the end of the case would be an automatic injunction like remedy with the exclusion order. So they're kind of 2 sides of the coin there. The potential for an injunction in district court is very hard to get these days. You have to really prove a lot of harm to your industry that couldn't be satisfied by monetary compensation. One of the other changes in the two different forums is the likelihood of getting to a trial. In district court, 3%, which is really not that many if you think about it, of cases go from the filing of the complaint through the entire process of discovery and then hitting the trial in front of a jury or a judge. The ITC, that number is much higher, it's 40%. And then the win rates are a little bit different as well. Patentees win about 1/3 of the time in district court, whereas at the ITC, they win more than half the time. And the time to trial is very different. The ITC is a much speedier forum, which is one of the reasons why a lot of companies like to go there to use it, particularly to protect market share, because you get a decision much faster. Typically within 9 to 10 months, you're going to have your hearing, and then the ultimate decision is going to come down roughly within 16 to 17 months. District court, it's going to take 2 to 3 years, depending on where you filed and how busy the court is. And then finally, because the ITC is a trade forum, you have to prove that you have investments here in the United States that would justify the remedy that they would ultimately provide. They don't want to just allow patent owners that don't have investments in the United States get the remedy that an ITC can offer. So you have to show that you do research and development here. If you make products here in the United States, that would be a great way of showing that you have a domestic industry here that's worth protecting. In the district court, none of that is required. Again, you can just be the patent owner and not make a product. You can simply use the patent as an offensive weapon to exclude others from that particular space. Let's move to the next slide. One other defensive strategy that is relatively new is called inter partes review, and that happens at the USPTO, the Patent and Trademark Office. And this was invented, or not invented, it was created by Congress about 10 years ago to give accused infringers a lower cost way of trying to defeat a patent. You don't get to litigate the issues of infringement through an IPR, through an inter partes review proceeding, but you do get to challenge whether the patent was valid or not. And so you go back to the patent office and you would ask the patent office to look at the patent again, and there's a set procedure for how that happens. It's lower cost. It also has a set timeline, which gives you a little bit more certainty. It also has a different standard of review, which may be a little bit Greek to a lot of you, but clear and convincing, which is what the district court and the ITC would require to prove a patent is invalid, is a higher standard than at the patent office, where you only have to prove that the patent is invalid by a preponderance of the evidence. And that means just something greater than 50%. So 50.1% would be enough. You also can use an IPR to leverage to get some sort of a license. The threat of canceling someone's claims through an IPR might bring the patent owner to the table more quickly. It gives you sort of a way to fight back a little bit. And often IPRs are used in conjunction with a district court case. So if a patent owner files in a district court case somewhere, you can file an IPR and then ask the judge in the district court case to stay, to put on hold the district court litigation so that the patent office can first decide whether the patent is truly valid. And that's another way of keeping the costs down. You're not trying to litigate both the district court case and the IPR at the same time. And the IPR would conclude first, and that would include any appeals from there. So IPRs offer a much lower cost. And by that, I mean, it's in the low hundreds of thousands to do one of these proceedings, whereas defending yourself in a district court can be in the high 100,000s or even more than $1 million to defend in legal fees and costs. So I want to now turn to another option that Larry's going to talk about briefly here on the next slide.
So as you all know, Amazon sells many, many products. And they've essentially, it's still a pilot program for them, but they have Amazon neutral patent evaluations that are very cheap, very quick, and very limited. And essentially, if you see a product on Amazon that you think infringes your patent, you can drop $4,000 to initiate the proceeding, plus whatever you pay your attorney, and have an Amazon neutral patent evaluator, which is just a patent attorney, experienced patent attorney that they hire to look at a few briefs going back and forth, and make an initial decision as to whether or not that product sold on Amazon infringes your patent or not. Any district court or ITC or USPTO ruling will trump it, and Amazon is going to be happy to flip it if another court gets it wrong. But this can be a very, very powerful and very, very quick and cheap tool to get this through. And if you are successful in blocking your competitor's patent, you actually get your $4,000 back. So this is a matter of months, and potentially in potentially even 4 figures for the proceeding from beginning to end. And I'll also just note that it's only available, for those familiar with Amazon products, it's only available for third-party sellers on Amazon. If you look on the Amazon webpage, they tell you if Amazon sells it directly or if somebody else is selling it through Amazon. If Amazon sells it directly, this is not available to you. But if it is a third-party seller, it's probably the quickest, cheapest, and easiest way to get it through.
I want to talk just a little bit more about ways to avoid lawsuits outside of the litigation or the adversarial process at the patent office. And that's something called a freedom to operate analysis. Just like the military, we love our acronym, so FTO analysis. And the idea here is really just, you're going to go out and look at what your competition is doing, both their activities as well as what kind of intellectual property they have. What are they doing in this space? What do they have to protect themselves in this space that you need to be concerned with? And ideally, you may want to do this before you really get too far along on developing your own products, maybe even before product launch for sure, so that you don't want to go down a path creating something and then realize that the 800-pound gorilla in this market space has the patent that first started all of this and can cover and block what you potentially do unless you take a license from them. So doing this freedom to operate analysis up front is a good way of knowing what's out there. You also have to keep in mind that, as Larry mentioned, there's ways of filing applications and not making them public right away. You're not going to be able to find those during your freedom to operate analysis. So there's always a little bit of uncertainty, a little bit of danger there, but you can certainly look at what's out in the public space already, see what activities they're doing, and then try to develop your own strategies based on what the landscape looks like. It can give you a little bit of peace of mind. It can also give your investors a peace of mind as well, that they know you've looked at what's out there and you've designed a deliberate strategy to sort of work around that and get your product to market and make it a distinct product potentially, and maybe make it a better product because you know what they've done and how you can improve upon it. We go to the next slide. And then if you do find patents or patent applications that you're concerned about, what can you do? There's a couple things. One of them is to obtain a formal opinion of counsel. So you would come to an attorney like Larry or I, and you would ask them to take a look at your products as well as the competitor's patents, and then ask them to make their own opinion on whether you infringe or not. Or they could also look at whether your competitor's patent was valid. That opinion of counsel gives you some peace of mind if they come up with strategies on how your product does not infringe or how the patent is invalid. That'll give you some protection that way. You could also, one strategy to consider is just approach the other side and say, we're looking at getting in this space. Can we license? Maybe they'll be offer favorable terms, or maybe there's some other sort of arrangement you can work out there. On the more aggressive side, you can look at filing an IPR, which is a post-grant challenge at the patent office. Post-grant means that the patent is already issued, it's been already granted. So you're going back to the patent office and you're challenging the validity, showing them prior art that the patent office didn't consider before. Or you can just get ready to litigate or get ready to file an IPR. You can still create your product, get yourself out into the market space, but know that the competition could come calling, could come threatening with a suit, and you're prepared and you're ready to respond if you have to. So those are some of the sort of strategies you can use, that freedom to operate analysis, to help you develop. And if you come up with nothing, unfortunately, litigation can always be a threat in the business space, honestly. There could be those unpublished patents lurking out there. And there could also just be folks that are asserting weak patents that they're really just they're not actually making products, they're not working in this space at all, but their business model is to potentially just assert patents to collect nuisance fees from companies that they sue. And if they collect enough of those, they can sort of generate a business model that way. So unfortunately, patent litigation or litigation in the IP space is sort of always a threat once you get yourself out into the marketplace. But there are strategies, as we've talked about here, to try to understand what the threat is and take action ahead of time if necessary. And that brings us to the end. I think we still managed to make it just on time. So if you have questions, please chat them. And I believe we can, there's some questions here. Let's see.
You can also raise your hand if you have questions. We have one, but maybe it should be a mistake. It's been up for a while. Valerie, do you have a question? No, I think it was a mistake.
Well, I do see a comment here about the cost, and that's you can, like a lot of legal services, you can shop around to try to get the best value potentially for your needs. But litigation can be expensive, and so a lot of the things that we talked about here is defensive strategies up front can help you reduce some of those costs, protecting yourself, getting your own position in the marketplace with IP.
Okay. I wanted to thank, it doesn't look like we have any questions. Last call for questions. You can always reach out, and this often happens afterwards. Feel free to reach out to Andrew or Larry with follow-up questions that you have. Thank you all for joining. It was a pleasure seeing all of you. We look forward to seeing you at the next one, which will be after New Year's in January. You'll get an invitation. And I just wanted to thank Larry and Andrew for great presentations, for their business focus, which is the most important thing here. It was very helpful. And again, the recording will be available if you need it. Have a great day, everybody, and thanks again.
Thanks for having us.
Thank you.